Yes. So thank you for giving me the floor, and thank you to Isabel Cecile for having me here and for this beautiful conference. And I've really learned a lot these last few days. So thank you. So just a few two disclaimers. This is work that is an empirical study that I'm carrying out with Professor Takis Tridimus from King's College, and we are working on it. We have hundreds of pages of tables of data, so this is what we have, the conclusions that we have reached so far. And of course, we have few conclusions and lots of questions. And also, I'm quite glad that my presentation comes at this stage, because it will spare me a few minutes explaining that we have analyzed economic agreements of the European Union, and those include investment and trade agreements, and because there is this general trend of convergence between dispute settlement mechanism in these two kinds of agreements. So I will be brief. So why have we done this work? We look at dispute resolution mechanisms in the European Union trade and investment agreements in force, and as you will see, are quite a lot. So we limit ourselves to those agreements, and we have done a road mapping exercise in order to assess the evolution of European Union policy and impact on this policy of the Lisbon Treaty, and also looking at why what the Commission has clearly decided that the best option for the European Union is the international court system, but are we sure that that's the only way forward or the best way forward? And so we want to identify patterns in these agreements. So the thesis is that the Lisbon Treaty has concluded for the moment, a process of constitutionalization of some particular feature of EU law that makes it different from any other order, as we know, of international law, and that the design of dispute resolution mechanisms now creates even more striking legitimacy issues. And among other things, of these features of the autonomy, there is this special relationship that from Van Genen laws, the European Union has somehow developed with individuals, which make of them a part of the constitutional structure of the European Union. Which one? Oh, yeah. Oh, here. Yes. And also this creates the constitutionalization of the European Union, of some constitutional features of the European Union also creates an enhanced need of accountability of dispute resolution mechanisms towards all the constituency of the European Union. There are institutions, member states, but also non-state entities. So in our idea, judicialization is a way that finds its peak in the international court system, is a way to address these constitutional features, to ensure that these constitutional features that constitute the autonomy of EU law are somehow respected in the external relations of the European Union, well, in the economic field at least. So what we've done is looking at 26 years of economic agreements, so all the European Union economic agreements in force or also provisionally in force. So there were 91 agreements, and 53 contain an arbitration or quasi-judicial mechanism of dispute settlement. Only 8 of these agreements only rely on political diplomatic means of dispute settlement. And we also analyzed, for comparative reasons, the TTIP ICS and also the state-to-state dispute resolution mechanism in the TTIP. And we used, as a watershed moment, to understand how these how this constitutionalization has actually had an impact on the design of this dispute resolution mechanism, we used 2009, so the entry into force of the Treaty of Lisbon. So the question was, what happened before, and did something actually change after that date or that moment? So in order to understand, to compare these treaties, these clauses and these chapters of dispute resolution, of course we had to find some comparators, and we developed a matrix of 16 indicators that, based on that in our view, and we use the methodology of Abbott of delegation effectiveness, create judicialization. So we believe that these indicators that I will show you in a few moments are based on two basic concepts. So delegation, because these dispute resolution mechanisms need to have some sort of delegation in order to work, but also effectiveness, because they need to be able, a dispute resolution mechanism that works needs to be able to impose its decisions over the parties. So the indicators are the following. I would not read all of them. I will spare you that. And so, but they include inter alia transparency, rules on compliance, timeframes, mediation, independence of the arbitrator, so how these arbitrators have been appointed, and what are the features that protect their independence, and do they have rules of procedures? Who set these rules of procedures? So the great majority, we have some general remarks. The great majority of these agreements, we said they contain arbitration and quasi-judicial dispute settlement. So we know that the European Union, in its economic relations, does rely on arbitration. And after 2009, there are a number of trends that have changed. So they don't regard precisely judicialization. I will go to that in a few seconds. But there are other trends. We have analyzed those, but they are not the subject matter of my intervention today. So just to point out that something changed also under different sense points, not just from the point of view of the judicializations, but something did change in the approach of the European Union after 2009 for other reasons as well. What the data say, that yes, there is according to those indicators, there is a process of judicialization. So, for example, there is more discretion given to the panel. There is third parties, NGOs, interested parties can generally participate more. We counted all of them. I have all the data, but we noted that there is a higher number of clauses. These clauses repeat more frequently. Almost all of the agreements signed after December 2009 do allow participation of third parties in the form of amicus brief in the dispute resolution settlement. But there is also the protection of the autonomy of the European Union under other points of view. So there is some more control. So that control on the arbitration panels does allow somehow the possibility to check what these arbitrators are doing. Why? Because of course the question is always there. So who are these people? How can they decide on some on the disputes? Who gives them legitimacy? So there are other means of control, such as, for example, transparency rules are much stronger, and they allow more control on the work of arbitrators. And also some effective tools to exercise autonomy, for example, that more precise time frames and the rules of compliance are much more stricter after 2009. So we would say the only, as I said before, we have few conclusions. One of the few conclusions that we have is, yes, there is a trend towards judicialization. So what comes next is a big question. We are working on that, and it does create a problem, especially in investment chapters. So we've seen that investment chapters are more problematic. We can discuss whether trade dispute resolution mechanisms do create the same problems. Under certain points of view, yes, they do, but they are less invasive, I think, of the sovereignty of states and the autonomy of the European Union. But what we do know today is that the design of these dispute resolution mechanism in the investment chapters of the European Union from now on will be possibly much more difficult. Mixity from the Singapore opinion, which arguably, and I will make a brief comment, I have to say it, I am not even sure that the court shouldn't have addressed the issue of compatibility with the autonomy law, because how can either the member states or the European Union be competent on something that is not constitutionally, violates the treaties? There is no possibility. I didn't agree. I think there is like is a bit irrational, and as this is something that Professor Tridimus, and I quote, said, the forgotten virtue of judicial discretion, because the most evident comment there is, well, but the court wasn't asked to decide on compatibility. Yes, it wasn't asked, but it carried out an analysis. He had all the elements to say, and I think we used the same reasoning they used in opinion 2015, possibly in the opinion on CETA, to say that it's not compatible. ISDS is not compatible, unfortunately. So we will have the apocalyptic scenario, and also the rules. The court said that the rule remains that dispute resolution mechanism as a matter of competence is ancillary to substantive provisions, but it just makes up a new concept of ancillarity, saying, well, it is ancillary, but insofar as it doesn't impinge into the interests of the member state, but this is new. It's something that wasn't said before. It's new, and who decide how much? Anyway, so mixity increases from the standpoint of design of dispute resolution mechanisms, increases the cost of including ISDS in new trade agreements, because there will be more procedure. There will be more procedure in the implementation. Well, in the ratification procedure, but also more procedure next agreements. If a member state, provided these ISDS are not declared incompatible before, but there will be more cost in negotiations between during the negotiations to make sure that member states do agree on ISDS before it gets to the stage of ratification. And I will be brief. I think I'm running out.
5 minutes, or even 7 minutes.
Great. So I'm being really quick. And yes, the separation between dispute resolution mechanisms and substantive provisions. So we said that this new ancillary test that was not there before, because the only test that we have was one of compatibility with the autonomy law. So this new test is even correct in law, because what make the creation of ISDS a new competence, and especially in foreign direct investment, because if we assume that we know that foreign direct investment is exclusive competence of the European Union, arguably, and I read a study, it's not me saying this, it's in an in-depth study of for the European Parliament. I can give you the details of that, but the dispute resolution clauses in investment agreements are an essential part of the investment chapter of the investment agreement. They cannot be decoupled so easily, and so it will almost be like having a rule but not an enforcement tool, because what is the alternative? Do we go back to government, or even to, as we said before, it was a really interesting idea, actually, I had never thought about it, so contractual arbitration, but that is not clearly, they contract with whom? So if we have an exclusive competence with the European Union and in foreign direct investment, so the contract between investor and the Commission. So
yes, why not?
Yeah,
we made that
mistake
for 1 century. So.
Yes. That's possible. I had actually never thought. It was really interesting. But I don't see how exactly, if ISDS is not compatible.
Well, you say that.
Well, I'm not saying this, but in the case where, in the apocalyptic scenario, how can we go back to the contract arbitration? That would be not possible. And so does this reflect the EU governance model? Meaning that is the court saying that the individual somehow is protecting individuals, saying you cannot take away from the national courts procedures, the judicial procedure, because otherwise somehow you deprive individuals of some guarantees. So is this a reflection of the multi-level governance of the European Union? So is the court trying to protect one of the constituencies of the European Union legal system? It could be, but as it was mentioned more than once in this conference, there must be a balance between autonomy is not an absolute concept. The European Union is not the only actor in the international scene. So somehow we have to balance an interaction between the European Union and other international entities. So conclusion, I will stress once again my only one conclusion, because it's the only one. So how can I go back? So my conclusion is, yes, there is a trend towards judicialization. This trend is more evident after 2009. So yes, the constitutional framework of the European Union does have, in fact, an impact on the design of dispute resolution mechanisms. There is this possible ambivalence of balance of the position of the individual on the European plane, because there is this necessity to protect it, but still allowing individuals to participate in these proceedings, so structuring this dispute resolution mechanism in a way that allows democratization in the sense of participation of through amicus curiae or through transparency is at the same time a way of protecting. And I would say even protecting more than on the national plane, because if we look at national procedures before national courts, I don't think the same rules of transparency apply on the international plane, for example, in investment proceedings. My national jurisdiction, there is no general rule for the public to participate into proceeding between other parties. You need to have an interest. Whilst a well-structured dispute resolution mechanism on the European level might somehow give individuals even more guarantees that they would be allowed on the national plane. And yes, I know it's questionable, but we can discuss about it. And I have strong ideas. And the question is, how much judicialization? So there is judicialization. We have witnessed this trend. So this trend points toward an international court system for the Commission. But is that necessary? Is that the only outcome? I am not convinced, because as we said, as it's been mentioned more than once in this conference, once again, there must be a balance. We are academics, but we must look at realpolitik issues, and we must look at also the practical aspect of things. So international court system is a very, very rigid system. We have an international court that may cost a lot, and is that the only way? Can we have something more flexible as, for example, a revised ISDS or something similar, but something that is actually workable in practice? So I welcome all your comments. So thank you so much. And